information. And then we'll get cracking here. Very briefly, looks like that's it. So we are now live on all the various platforms. Hello, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler, and I am a criminal defense attorney here in Scottsdale, Arizona. My team and I, we've represented thousands of people over the course of many years, and in our practice, we've seen a lot of problematic things that exist in our criminal justice system. We're seeing a lot of it today in society. Every time you turn on the news, there's more protests, there's more misconduct, there's more police in trouble, there's more citizens in trouble. It kind of seems pretty chaotic. Now, we've been following this stuff for a very long time, and we decided to start this show called Watching the Watchers because we wanted to hold those in our justice system accountable. I'm a defense lawyer. I work on the defense side, and so I only have certain tools. There are only certain things that I can do. A lot of the power, a lot of the room for improvement in our society, in our justice system, lies in the hands of the government, lies in the hands of the prosecutors, the judges, the politicians, and the police officers. And so when we start seeing misconduct around the world, around our country, around our states, around our local cities, there's a big problem there. And in our opinion, the best way to help eliminate the problem is by shining some sunlight down upon it, by increasing transparency, by talking about this stuff, and by enlisting you, people who may not otherwise be practicing in this space or living in the criminal defense world. If you're interested in these topics, and you can reach out to your representatives, to your local municipalities, and ask them for some change, then maybe we're going to see some improvements throughout our society. So today we're going to dive into a lot of the cases that we've covered previously on this channel. If you are a regular here, good to see you again. If you're not, if you're a new viewer, a new YouTuber, hit the subscribe button because we cover a lot of these cases in depth, really high profile cases. And today we're going to revisit them. It's been sort of a slow news week, which is good. We don't want more problems. We don't want new cases that we have to cover. But today's a good time for us to go back and look at the stuff we've been covering previously. And of course, I'm talking about George Floyd. That is on the agenda today. We've got Kyle Rittenhouse. We're going to talk about some updates in his case. There was some news in the Breonna Taylor case. Her case has been something been going on for a long time. There's been some interesting developments there. We're going to talk about it. We've also got Ahmaud Arbery. Do you remember that one? This happened sort of pre-coronavirus or right around the time when it was really sort of manifesting itself throughout the country. We're going to give some updates on the Ahmaud Arbery case, specifically about Gregory and Travis McMichael. And of course, we've got the McCloskeys. The McCloskeys, you remember them? They were the couple who was in front of their house with their firearms. They got charged, or they're in the process of being charged with crimes. We've got some updates for them as well. So this is a live stream. So from time to time, I intend to try to remember to stop and take a look at your comments and see what you have to say, or if you want to chime in, feel free to do that. We're going to revisit some of your comments as we go through these. There will be breaks for us to review what we just discussed. So feel free to sound off in the comments and let's get started. So as I mentioned, there are updates in the George Floyd case. Now, this is a case that is, I think, going to be going on for a very long time. George Floyd, as we all know, is no longer with us, but the 4 police officers who were involved in this entire ordeal, their cases are going on. And there's been some interesting things happening. Now, I talked about this at length in a prior video this week, but let's revisit some of the stuff because there's some new documents that were filed today. Let's take a look. So this of course is who we're talking about. We're talking about George Floyd and Dereck Chauvin. George Floyd was, a quick recap, he was on the ground. Dereck Chauvin had his knee on his neck for a very long time, resulted in him dying. And today there was some new stuff that came out. So this was a new filing. This is what's called a supplemental prosecution disclosure that goes out in most criminal cases. So let me walk you through a little bit about what this says. Disclosure. So when you're talking about a criminal case, disclosure is essentially evidence. So let's say, for example, you're in a DUI case. The government has to tell you what you've been charged with. They have to give you the police report about why they stopped you and about how you did on the field sobriety tests and about what your blood results are and all of those things. They have to give that to you. The government has the evidence. They're the ones who generate it all, so they have to give it over to you. That's called disclosure. So in this case, in George Floyd's case, there has presumably been a lot of disclosure going on, But today, the government filed what's called a supplemental disclosure pursuant to their rules, which means that they have more information. There's more details about this case that they are going to be giving out. And so let's take a look at what might be in there. This is the supplemental discovery motion, and you can see here that a couple of these line items are checked. We have the police investigative reports, so there's more of those that are going to be disclosed. We've got statements relating to the case, very generic, very general. And then we have some photographs, videotapes, audio tapes, and DVDs. These are all being sent over to the attorney for Dereck Chauvin. This is McMichael Chauvin's case. We're going to really be focusing on him. I'm not going to spend too much time focusing on the other three co-defendants. These are the other three officers because they're essentially the same case, and I think Dereck Chauvin was the most complicit. This was the worst of the four, so we'll focus on him. Now, that being said, there are some interesting sort of differences between some of these cases. From what I can tell, I haven't really spent a lot of time going into the other three cops, into their cases specifically, but they all have different lawyers and they're sort of pointing the finger at each other. And so this is going to be an interesting case. They're all going to be sort of deferring about who was in charge of the scene, who was responding, who sort of assumed command while they were there. And so this is going to be very interesting to follow along for the foreseeable future. But when we go back, we're going to see that there's just more stuff that they are passing along to the defense, in this case to Eric Nelson, who is the criminal defense attorney for Michael Chauvin. In addition to that, we've got some other things that are being disclosed. We have the business, the public records here. We have something else, and that's about all that we know. You can see the rest of this is just pretty standard language. They're telling the defense attorney that you can't give this stuff out. You can only use this for your defense. Otherwise, you gotta hang on to it. In other words, you can't publish this stuff or you can't disclose this to anybody. So very generic. There's more discovery going on. These types of cases are interesting because there's typically a lot of interviews that go on. So, the investigators from all of the different agencies who are working on this case, they're going to be interviewing people. And so these discovery files can be huge, thousands and thousands of pages, thousands of transcripts, audio recordings, and so on and so forth. So this is not unusual. There's always this kind of trickle of new evidence, new disclosure that comes out over a period of time. And so that's what we're looking at here. There's been some other interesting things. Now, this is the stuff that I covered at length, I think, for a 30-minute video, but let me just give you a quick recap on this. So last week on Friday, there was a proceeding that took place in Minnesota in Dereck Chauvin's case, and something happened on that Friday. We really don't know what it was. But then on Monday, something very interesting happened because the prosecutor's office actually filed a motion, sort of it felt like out of the blue because we weren't at the hearing on Friday. But what they're asking the court to do is basically reverse itself. So they're saying to the court, we know that the judge, we know you did something on Friday. We don't like what you did. So now please reverse that. That motion went out bright and early, or actually it was at 2:23 their time on Monday. So court happens Friday, the government files a motion Monday, and they're concerned because on Friday it looks like the judge actually disqualified 4 prosecutors who were working on the case, including the county attorney. So the head prosecutor for the county, or it may have been the attorney general. Anyway, somebody very high up. It was the county attorney, Michael Freeman, who is disqualified from the case. What the heck is that all about? Well, this is what the motion looks like. This is the state's notice of motion and a motion for reconsideration of the order prohibiting the participation of Michael O. Freeman. So what happened here is the judge said that this person is prohibited from working on this case. Michael O. Freeman and all of these other people are not allowed to work on the case. And the crux of that, the basis for that was that there was this violation. The judge believed that there was some impropriety about the interview that the prosecutors had with Dr. Baker, who did the autopsy in the case. They're saying that there was some improper meetings that took place, and they violated what's called the witness advocate rule, which is pretty important. So that's what happened. The government came back and they're saying, no, please don't disqualify us. Let us know, what you really meant in that oral motion or that oral order that took place on Friday, and we're going to learn more about what that judge said specifically. So the ruling on that should be forthcoming. Here is a copy of the minute entries from the court. You can see here that this hearing took place on 9/14. And all of this was taken under advisement on the 14th. They rescheduled the court date on 9/18. So this Friday, we should have some idea on what the judge is actually going to rule. So the government filed their response. They said, please don't kick us off the case. And now the judge is going to issue their ruling, presumably on Friday. So we'll keep you up to speed on that. This is a good time to hit the subscribe button so that you can follow along when we have these updates. And we're going to do these updates more regularly just so that we can stay on top of this stuff, because this stuff is happening relatively quickly. We want to make sure that we can keep you apprised of that. So nothing super groundbreaking there. This is all pretty traditional stuff, just more disclosure, more hearings, more rulings, except that they're trying to throw out the county attorney. They're trying to get rid of 4 really high up prosecutors in the county attorney's office, which is unusual. I mean, we just don't see that happen often, if ever. This is kind of a big disqualification if the judge makes it stand. They're going to disqualify the entire the county attorney and basically 3 of his deputies. So we'll see what happens with that, and we'll have an update on Friday. All right, the next update that we have is about Breonna Taylor. Remember Breonna Taylor? Remember this young woman? Okay, she was 26 years old when she was shot and killed by the police out of Louisville, Kentucky. This happened on March 13th, 2020. You may remember the story. We covered this one a long time ago, right when it happened, and this has been something we've been following for a long time. Now, she was in her apartment, in home, asleep, when the police were approaching her apartment. They were going to do a drug investigation or a drug raid. Her boyfriend, Kenneth Walker, saw the police coming in, thought it was an intruder. He picks up his firearm. He fires towards the cops. The cops just fire sort of haphazardly back towards his direction. He's not hit at all, but Breonna Taylor is hit, and she's actually shot and killed. And we went through this case in great detail. You can look up one of the prior videos and sort of see what the cops were looking for and how they shot and how this whole scene went down. But it was horrendous because there was a lot of malfeasance. There was a lot of mistakes that were made. You can go back to it. I don't remember the details specifically, but I think they were at the wrong house. And they had the other guy who they were really looking for in custody in a different police precinct. And so all sorts of problems. And the big question was, what's going to happen with this case? This all took place before George Floyd, before most of the country was really sort of invested and involved in this criminal justice reform movement. It was before BLM was around, before the peaceful protesters, before the non-peaceful protesters. So this case kind of at the beginning fell off everybody's radar, but now it has sort of picked up a lot of steam, and people were really concerned, and they're wondering, are these cops going to get charged with crimes? And that was the reason we were following this case along. But then something happened this week, which sort of makes me think that's probably not going to end up happening. So we have Breonna Taylor. Her family is to receive a $12 million settlement from the city of Louisville. This comes from the New York Times, written by Rukmini Kalimaki, and she says that in the aftermath of the botched police raid in which Miss Taylor was killed, the city agreed to institute changes to prevent future deaths by officers. So let's go through this story a little bit. You can see here that after months of protest, the settlement was reached. $12 million. $12 million will go over to Breonna Taylor's family. And they're also going to institute some changes aimed at preventing future deaths by officers. So we'll dive into that a little bit. The agreement, however, did not require the city to acknowledge any wrongdoing. It was sizable. Her family received more than double the amount that relatives of Eric Garner, which was another guy who was killed by the New York police in 2014. And another segment of the article that I just clipped, this is not all, these paragraphs are all clipped sort of however I wanted to do it. It says the policing changes would require more oversight by top commanders. So these are the changes. So Breonna Taylor is going to get $12 million, or her family is going to get $12 million, which is, a significant amount of money, but I'm sure the family would trade that money in a heartbeat to have their daughter back. Regardless, it's a nice chunk of money. A lot of the times when they're going through these settlement negotiations, they're going to be be asking questions like, how old was this person? What kind of job did they have? What was their future earning capacity? What is the political climate? And obviously this case is a little bit different. Most people who are entering into settlements with the law enforcement officials, they are not part of national news. Most of these settlements are done really hush-hush, kind of quiet, by the wayside. But Breonna Taylor's case had a lot of people who were very, very interested in this. And, this was actually leading to a lot of civil unrest and a lot of concerns, political concerns for the upper echelons of the police and the city council and everybody in the government. They all wanted to make this go away, which in my opinion is probably why the settlement is so high. And $12 million is not insignificant. And so they took that deal. And I think that this is probably going to be the end of this case. I don't think that they're actually going to get charged. Here's why I say that. So in addition to the $12 million, they were also going to institute some safeguards. Number one, they're going to require more oversight by top commanders. And I don't even know what that means. There's just a news article today that I'm not going to cover on the show today, but is from the city of Phoenix. The city of Phoenix police chief made some statements to a news reporter here at ABC 15, Dave Biscobing, and she basically said, I don't even know how the Brady system works. I don't even know how any of the mechanics of this work. I don't know how these records are maintained. I don't know how they're stored. I don't know how they're disclosed. No idea. So when they use this type of language, when law enforcement or any government entity just says, well, we need more oversight. Think about all the places you hear this. How many times do we hear about more oversight? We need it in the financial industry. We need it in the healthcare industry. We need it in the insurance industry. It's just a generic buzzword. I don't know what it means. Can somebody tell me what that means? More oversight by top commanders. I have no idea. Then the next thing they're going to do is they're going to make mandatory safeguards that were common practice. They're going to make mandatory the safeguards that were already in common practice. So that's going to be, basically saying, well, this was already good practice. We were doing that anyways, but now we're just going to make it mandatory. So the cops should have been doing it. They weren't doing it. So now we're just going to say that they should do it again. Okay, so they're going to make it mandatory. I don't know what safeguards they're talking about specifically. Maybe they'll detail that for us. And, this is not the author of this article. It's not her fault. She probably, wasn't specifically asking these questions, and there's probably not any good answers to it anyways. But what were those safeguards that they should have been following, but that weren't mandatory? If those same safeguards would have been mandatory, would Breonna Taylor still be alive? Who knows? Who knows? That's anybody's guess. And then finally, the last thing they're going to put in place is an early warning system to flag officers who have been accused of excessive force. So, good stuff. I think if all that goes through, certainly more oversight. If it's productive oversight, that would be good. If it's just, what I think a lot of the oversight looks like right now, it's just sort of looking at, oh, that looks good to me. That sounds about right. I think we'll let that one slip through. We need more than that. We need some concrete rules. We need more detail on what that means, because as far as I'm concerned, any politician or any city council member or any of these people who just beat the more oversight drum, I don't know what that means. And I don't think they do either, quite frankly. So we'll see what happens with this case. It is important to note. Let's take a quick look. Let's finish the article. It says, since the young black woman's death, the top demand of the protesters who gather nightly in downtown square have been that criminal charges be brought against the 3 white officers who shot Ms. Taylor. So officers were fired upon first. So legal experts say that their actions may be protected under Kentucky's statute. And for that reason, they're saying it is unlikely that a criminal inquiry being conducted by the state's attorney general will result in charges against at least 2 of the officers who were standing directly in front of Kenneth Walker. Third officer has been fired for shooting recklessly that night, but the results of the attorney general's investigation are expected to be released soon. If no charges are brought, or if the charges are minor, the settlement announced this week may be the closest Miss Taylor's family comes to justice. And I think that's probably going to be the case. I think there's probably, this will never make the settlement agreement. This will never make the news, or nobody will disclose this. But it sounds like kind of a quid pro quo thing going on here. Maybe the government said, yes, we'll give you a higher settlement and will agree to these reforms so long as you forego or you stop sort of advocating that additional charges be brought. So in other words, let's put this whole thing to bed. We're going to give you $12 million. We're going to agree to these sort of minor talking point token reforms for our justice system. And in exchange for that, we're going to ask you to just leave this thing alone. So no longer be the spearhead of this, no longer be, on TV and raising money and all of that stuff. They're going to forego, I would guess, as part of the settlement agreement, just speculating, they're going to forego any other civil claims against the government. And the attorney general or whoever's doing the investigation there out of Louisville, it'll be up to them to decide whether or not to bring charges. But based on the fact that they're paying $12 million, I think that's going to be sort of like that quid pro quo. They're going to say, here's $12 million. We're not going to bring charges, and we're just going to wrap this whole case up. We'll see what happens. I would not hold my breath. If you were looking for those individuals to be charged with a crime for that, wouldn't hold my breath. And that is Breonna Taylor's update. Maybe the last update. If anything pops up, we'll let you know. But that may be it. The settlement may close that case from this chapter. All right. Next up, we have, this is going back a little ways. This goes back to February 23rd. In Georgia. We're talking specifically about Ahmaud Arbery. Remember Ahmaud Arbery? We've got Gregory McMichael there on the left. We've got Travis McMichael on the right. This was a pretty big, pretty controversial case that took place out of Georgia. And as a quick recap, let's remember what happened. The original claim was that Ahmaud Arbery was running down the street and he was just going for an afternoon jog. Travis McMichael, Gregory McMichael were both there in the neighborhood. Gregory McMichael was a former police officer or investigator or had some involvement with the prosecutor's office in his locality. And they decided to take things into their own hands. They thought that there was a series of break-ins going on, and because they saw a black man running down the street, they thought that was the person who was responsible for it. They get into their car, they chase him down, and when he sort of continues to flee from them, they circle around, block him off, they kind of barricade him in, and then we saw that video that was very short, very shaky, very grainy, but Travis McMichael, the son, actually pulls a shotgun on him and shoots him, ends up shooting him 3 times. Ahmaud Arbery, of course, dies. And this was a case that sat around for a long time, about 60 to 90 days. It sat in the prosecutor's office. It got kicked around by multiple different prosecutors. Nobody wanted to bring any criminal charges against the McMichaels for false imprisonment or for murder or for getting involved in something that they shouldn't have been getting involved in, for not calling the police and letting them deal with it. All sorts of complaints about this. Then somebody leaked a video. I believe it was the defense attorney leaked the video to the public, and we all saw what happened here. And then we got to sort of put things back together and say, why did it take so long for anybody to look into this? And it turns into this situation where the public starts clamoring. They get sick and tired of this whitewashing, of this trying to sweep everything under the rug, and they demanded that charges be filed. And they were. And so Travis and Gregory McMichael and their friend, a neighbor, Roddy, were all charged with various different crimes. And, a lot of the time, my perspective on these things is I get concerned that once the initial outrage, once the initial furor sort of dies down, I'm wondering if these cases are just going to fall by the wayside. Everybody's going to forget about them, except this channel, of course, which is why you're here. But what we want to do is we want to just continue to follow them along. And actually, there's some pretty interesting things going on here. It looks like that the prosecutor's offices are actually not letting this one up as lightly as I would have otherwise thought. And so today what we saw, there were new filings literally that happened today right before the show started. We have out of the state of Georgia, out of Glynn County, we have notice. The government is filing an intention. They're letting the court know that they intend to introduce evidence in aggravation of the punishment. So notice of the state's intention to introduce evidence in aggravation of the punishment. So let me explain what this means or what this type of motion is. So let's say you probably have heard of mandatory sentencing. You've probably heard that, if you go to trial and you lose, if you're convicted of a crime, the judge can only sentence you to a certain range. So they can say, well, you're going to get 5 to 10. You probably heard that, right? That means that the judge can't give you less than 5 years, but can't give you more than 10. Has to sentence you within that range. And so when you're looking at that sentencing box, and in Arizona we use charts, we have these spreadsheets and charts and these little formulas and we can flip through them and all that stuff. What we're talking about is when you say, okay, in that 5 to 10, we say that most cases will start at what's called the presumptive. So we'll start at, let's say, 7. So if you got charged with that crime and convicted, and I did too, and my friend did too, we're all going to start at 7 years. And what the defense's job is to try to do, it's to work the case down. We want to work it as close as we can possibly get to the 5 years. Let's work from 7 down to 5. The government's job, or what my perspective on their job is, they may disagree with this, is they're trying to push it the other way. They're trying to maximize it. They're trying to aggravate it. So how do they get from 7 to the 10? They introduce aggravating factors. And what they have to do in order to have the judge know about that and to actually sentence this person is they got to tell the court. And so that's exactly what they're doing here. They're filing a notice of the state's intention to introduce evidence in aggravation of the punishment. And we can see here, they're just saying that in the event of a conviction, the state will take the following action at the sentencing phase of the said trial. So this is not going to introduce anything into the underlying trial itself, but the state intends to introduce evidence that that there are other, any other convictions, any other juvenile adjudications, any other crimes of the defendant that they learn about when the government gets discovery back. Remember, we talked about the government has to disclose evidence to the defense. The defense has to disclose the evidence that they want to bring at trial back to the government. And so this portion of this is saying that if they learn that there are other convictions, they're going to use that to aggravate the sentence. They're also going to be saying that they intend to seek punishment of the defendant, which would authorize this court to impose a sentence of life without the possibility of parole for a conviction of the offense of murder. So they are saying that they are going to be asking for the maximum. And they have to put, a lot of the time when you have these state statutes that you're going to be asking for life in prison or the death penalty, you got to notify the court. And so that's what they're doing here. I was sort of the mindset, and this could certainly change. This could be just formulaic, and they're just filing this as a matter of due course, and then they're going to offer them a sweetheart plea deal later down the road. That could be the situation, or it just could be the situation that they don't intend to offer a plea deal at all. Maybe they have more evidence. Maybe they have evidence that we have not seen yet. Maybe they've got text messages or emails or phone calls or other witness statements that indicate that the McMichaels are even more culpable. The sort of the situation was even more egregious than we as the public knew. And remember, most of this stuff came out through leaks. This was before, this was pre-George Floyd. And so a lot of the immediate transparency that the public now expects and that the police departments are actually sort of evolving into, a lot of in Phoenix, they have really rapid response now. They're getting these body cam videos out to us quickly, which is great. I think that's good. We want more of that. We want more transparency. But my point is, there may be more stuff that the government has in their Travis McMichael file that we don't quite know about yet. So that was interesting. They are going to be at least notifying the court. They're going to be aggravating the sentence for both the McMichaels, and we'll see where that goes. We also have some other interesting things that came out from the court today from the state. This is the state's notice of jury instructions. So it looks like in Georgia they call this the state's request to charge. And so you can see each one of these different charges. All they're doing here is they're basically asking the court to take notice of the jury instructions. So when you go to trial and you have a jury sitting there, both sides are going to present their evidence. The government's going to go first. The defense is going to go second. We're going to have our opening arguments, present our evidence, have our closing arguments. And then the jury is going to have to take those facts that they just listened to, and they're going to have to apply the rules to the facts. And so there can be a lot of argument over, what are the rules? Like, what is the jury going to be looking at? What are the documents that they're going to compare the facts that they just saw in trial to? If this is the law and these are the facts, they're going to need to hold the two side by side and say, yeah, that looks like he hit the facts that were in this law, and that's going to be guilty. And so they need to know, what does the law say? What do the rules say? And so this is what the prosecutor's office submitted to the court. That would be their proposal for the jury instructions. And they are including the murder definition. So they're including malice murder, which is intentional murder. And this is what they're going to be instructing the jury. They're going to say a person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. And so this is the rest of the statute. It says down here, Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted, yet if malice is in the mind of the accused at the time of doing the act or killing and moves the accused to do it, such is sufficient that okay, so you see what's happening here. You've got all of this language. This is all being proposed by the prosecutor's office. The defense has an opportunity to come back and say, actually, you know what? We don't like that explanation of the law at all. Maybe they come back, and I don't practice law in Georgia, so I don't know the specifics here, but maybe they'll come back and say, well, yeah, we actually disagree with this. We think Georgia law, we think this statement that it does not require premeditation, we think that's a little overbroad. We actually think that it may actually require premeditation. So they can argue over these jury instructions, and then the judge will ultimately, be the final arbiter of that, make a decision. And then when the jury goes back into the deliberation room, they're going to have these sort of agreed upon jury instructions that they can refer to when they're going to be making their decision as to whether the McMichaels or innocent are guilty. So they are including the malice murder. They submitted a ton of jury instructions over in this case, so we'll see where that goes. We also have a scheduling order. So we have some idea on when more stuff is going to be happening in this case. And it's coming up in October, November, and December. We had some earlier deadlines, but the defense, so the attorneys for the McMichaels, they actually asked for significantly more time. They wanted additional time to review all of the evidence that they have been given. So the prosecutors would have given them a lot of material, and they said, we don't have enough time to review all this stuff. And so they filed a motion, and they sort of detailed a lot of the materials that they got. And it is a ton. It is a lot more than the public has any idea. And so let's take a look at what they included in their motion. So they said that the state gave them the first round of discovery. Remember, discovery is the evidence. During the week of July 19th, the first round existed of 47.3 gigabytes of data. That is 1,600 pages, 1,635 pages, and it consisted of video interviews, police body camera videos, cell phone extraction reports. So they pulled out all these different files, 489 media files. And then there's going to be a second round of discovery, which is going to be even bigger. It's going to be about 5 times the size. The state will provide a second round of discovery consisting of about 260 gigabytes of data within the next day or so, which is a ton. I mean, that is a lot of material. Now, this is a big case. There's a lot of witnesses, a lot of calls, a lot of interviews, multiple defendants. We have a dead young man, and there's a lot to review. I didn't expect it to be that much stuff, but there's a lot. And so the defense asked for some additional time, which of course is absolutely reasonable, right? You want to make sure that the McMichaels have the best opportunities to review all of the evidence and to build their defense and have their day in court. This is due process. This is how our system works. And so the judge actually did grant them some additional time. Here is what we've got. We've got the final order comes from this is the order. This is a scheduling order. And so you'll see here a couple different dates. We've got the defendant's deadline for providing discovery shall be October 30th. So that means that the defense has to tell the prosecutor about the evidence that they have. We have another deadline on November 30th. So that's going to be the defendant's deadline for filing what are called pre-trial motions. And then all responsive pleadings shall be filed by December 31. So we're going to start to see some action on this case. We may actually see some results or some indication of what's going to be happening by the end of this year, which I think is on track. Now, I don't expect for this case to be closed this year. Normally, I would say these cases take a year to 2 years to resolve. And so if this extends literally into 2022, I would not even be surprised. But it does sound like the judge is holding this pretty tight. They asked for more time. So they asked everything to even be pushed back further than this, the defense. And the judge said, no, we're going to give you, we'll say till the end of October, but not until the end of November. So we're going to give you another 30 something days, but you got to get moving on this. And so they really got, there's a lot of work to be done. That is a ton of discovery. So hopefully they have everything they need to do that. And then all of the pre-trial motions need to be filed by the end of November. So the defense, when you're in a criminal case, you can file what are called pre-trial motions. So you can say, I want to exclude that cell phone record, or I want to suppress this evidence, and here's my basis for it. So all of those types of motions need to be filed, and they need to, disclose their witnesses, their experts, and all of that stuff by October 30th. So this case is going to continue to develop, and we are going to follow this one along. I think this is going to be interesting. We're going to see what happens, because we have a former police officer, former investigator, who's being charged with a crime, in my opinion, in a very friendly county. He worked with a lot of these people for a long time, and I know they're bringing in outside sources and other agencies to help and assist in the prosecution, but we'll see what ends up happening there. All right, so let's move on to the next update. More updates today. And next, do you remember the McCloskeys? Patricia and Mark McCloskey. So remember these two? This happened back in June 2020, and this happened in St. Louis, Missouri. We have Mark and Patricia McCloskey. Kim Gardner was the prosecutor, and I've got other videos on this channel talking about some of the conduct of this prosecutor and how insane it was. But here we are. We've got the McCloskeys. Their case is still going forward. And this week we learned some additional things. We learned some interesting stuff, in particular, not about the McCloskeys, but more about the prosecutors, more about the people who were charging the McCloskeys with the crimes. What happened after this whole ordeal? Do you remember? Let me do a quick refresh on the McCloskeys. McCloskeys are ultra wealthy. They have a huge mansion, and they are living in St. Louis, Missouri, and the BLM protests are going on. They're marching down their street. The McCloskeys live in a private residence, so their house is gated, and the BLM protesters, or the protesters, maybe they were Antifa, who knows anymore at this point, but they broke through the private gate. We had pictures. We covered this at length on this show, and we saw that they broke the gate down, and they basically marched up onto the McCloskeys' private property. The McCloskeys grabbed these firearms, as you can see here. They grabbed some weapons, and they decided that they were going to be protecting their property, as, in my opinion, was 100% their right. They had every right to do this, but for some reason, the prosecutors came and they charged them with crimes for brandishing firearms and for all sorts of ridiculous nonsense. So they brought those charges, and now what we're talking about is, what were the prosecutors doing? What were they thinking at that time? I was always concerned about that. We reviewed many of Kim Gardner's, who is the head prosecutor there, statements and some of the actions she was doing, and it didn't make any sense to me, but fortunately, we do know a little bit more about them. So this story comes from KMOV4, and we see here this story was published yesterday on September 15, 2020, written by Lauren Trager. It says, the McCloskey case, a rare look at prosecutors' emails, reveals improper urgencies to charge, the attorney says. News 4 received a series of texts, emails, text messages, and a voicemail exchanged in the days leading up to Mark and Patricia McCloskey being charged. Okay, so that sounds interesting. What does the article say? It says, for the first time, News 4 is getting a rare look at what went on behind the closed doors in the days leading up to the charges being filed against them. Through an anonymous source, News 4 received a series of emails, text messages, and a voicemail exchanged in the days and weeks leading up to Mark and Patricia McCloskey being charged for what happened in their home in West Central End. In a voicemail. So we're going to have a couple different people who are exchanging this information back and forth in a voicemail. The St. Louis Police Sergeant, Detective Curtis Bergdorf, which is an amazing name, Curtis, and the Assistant Circuit Attorney and Chief Warrant Officer, Chris Hinckley, they're communicating back and forth. And the Circuit Attorney is a prosecutor. That is somebody who presumably is working with the prosecutor's office, and they're communicating with the St. Louis Police Sergeant and the detective to decide what to do with this case. Should we charge these people or not? What's the deal? So the prosecutor calls over to the detective and says, Curtis, you need to call me back. I wrote a long email to you trying to ask a bunch of questions about what you said. Some of it was expletive. And so I don't know what expletive that could have been. There's a couple that come to mind, like the F1, or some of it was S, that was just, you can fill that in with what you think is most appropriate. But now we need to straighten this out, he says, because I am done with this crap, Hinckley said. So this is a prosecutor responding over to the detective, who is the lead investigator. The next sentence says, Bergdorf is the lead investigator on what happened at One Portland Place on June 28th. Since then, prosecutors have charged the McCloskeys with exhibiting weapons, and 9 people have been issued citations for trespassing on private property, which is news to me, right? For the longest time, when I was reviewing this case and all the news articles were coming out and Kim Gardner was making her public statements and everybody was sort of trying to beat up on the McCloskeys, everybody was saying that these were peaceful protesters and they weren't doing anything wrong. And they were just, peacefully walking through the gates, and the gates were open, even though we had pictures of the gates being smashed. And the McCloskeys were ridiculous. They had no reason to fear for their safety or for their well-being because these were peaceful protesters and they were doing nothing wrong. Well, we fast forward and now we learn 9 people have been issued citations for trespassing on private property, which I don't know how it works in St. Louis, but in Arizona, trespassing on private property is a crime, meaning you broke the law, which is essentially the same thing that we've been saying from the very beginning. So if 9 people broke the law, they were trespassing literally on private property. What the hell are they charging the McCloskeys for? Why would they even be charged with a crime? There were people, 9 of them, by the government's own admission, who trespassed onto their property. And so they grabbed their firearms to protect their property against a mob who was chanting and breaking down gates and who then also broke the law. So Kim Gardner decided that they were going to charge him with crimes. Again, I have no idea what is going on with that prosecutor, but here we are. The article goes on. It says that the Hinckley got heated over the probable cause statement. He outlined outlining the charges against the McCloskeys. So Bergdorf, who is the detective, created a list of 14 reservations about how Hinckley had written it, claiming they weren't factual, including the use of the term assault rifle. So the detective Bergdorf said that was a propaganda term, which I think he's right on that one. Hinckley responded, "I'm more than willing to remove the term, but in alleging I'm using propaganda, you've crossed the line. If anything, your changes, conduct, and unexplainable edit in the PC, which is the probable cause statement, strongly hint of bias or agenda." So you see these two guys are sort of going at each other to try to figure out what to put in this probable cause statement, and they're trying to sort out what to do with this case, probably because they both know this is nonsense, and they're trying to manufacture a basis for criminal charges against the McCloskeys, and they're getting frustrated doing it, rightfully so. And so on the McCloskeys case, we see here that the St. Louis police declined to comment because the case is pending in court, and in fact, the case is still with the grand jury, with the McCloskeys' next court appearance in October. And so this is interesting. The McCloskeys are very affluent. They've got a lot of resources. I know Mark is an attorney. I think Patricia may also be an attorney. So they're very well plugged into this. They know how to handle these cases extremely well. And as they were going through this entire ordeal, I'm sure they had that. They knew that. They knew that they were going to be okay and that they had the resources to fight this thing off. But many people don't. Many people don't live in mansions. Many people don't, have the ability to just, hire high-powered lawyers to handle this thing. There's a news story going around I saw just very briefly today about supposedly another Trump supporter who was arrested out of his own home. He was in his home for brandishing a weapon. There was some BLM or some Antifa protesters who were outside of his house, and he was brandishing a firearm. And so I'm going to definitely dive into that story when we know a little bit more, but this sort of resembles that. This is a situation where if you are a person without the means and without the skill set to represent yourself in a case like this, you can absolutely get steamrolled. The McCloskeys are certainly not getting steamrolled. If we look over, we can see from the court records that they have filed a number of different motions, and they're working very hard to disqualify the prosecutor's office. And I think they've got a pretty good case on this. So the McCloskeys have filed what's called a motion to disqualify. They're filing a supplemental motion to disqualify the circuit attorney, Kimberly Gardner, and the entire circuit attorney's office. They've got multiple exhibits, and they're filing that with the court. And it was filed by their attorney on behalf of Mark McCloskey. We've got additional motions being filed, memorandum. We've got all sorts of stuff. And their next court date is going to be on October 6th. But what they're doing is being very aggressive. It sounds like the case is still with the grand jury. So it sounds like they haven't even been indicted yet. And so I'm not real sure what that court proceeding is going to be, if it's a status conference or whatever it is. We can't actually see the title of that down here. We can see it's with Commissioner Michael Colonna, Division 25, but that's about it. We don't know what that hearing is going to be, but the McCloskeys are trying to disqualify Kimberly Gardner. They're trying to get rid of the entire prosecutor's office, and they may have a decent basis for it. Some of the article says that Kimberly Gardner was actually using the McCloskey case in fundraising campaigns and to generate money for her campaign, and that obviously would be a major problem. Can't prosecute somebody and then use them to raise funds for yourself. I mean, that's such a massive conflict of interest. That would just lead you to go prosecute people only for the purpose of generating revenue for your reelection campaign. Obviously, that would be a huge no-no. And so the prosecutor's office, they're going to respond back and they're going to say, no, none of that should happen. And, we should stay on the case. There's nothing unethical about this. But it's difficult to know what Kimberly Gardner is saying or what her position is when there's really very little. She's not willing to give any public statements about any of this stuff. So we'll have to wait until the courts sort it out. And they will. So we'll continue to follow this one along because we are seeing this very subtle encroachment on a lot of on the Second Amendment, on the ability to protect yourself, the rules around self-defense, the ability to use a firearm to protect your home, to protect your property, to protect your livelihood. And this assault kind of just continues on, which leads us to our final update of the day. And of course, we are talking about Mr. Kyle Rittenhouse. So Kyle Rittenhouse has had some interesting developments this week. Nothing super substantial, but there's been a lot of concern in the legal community about what's happening on his case. Where is he? What's going on? What are these attorneys doing? I did a long show last week. We did a deep dive into his defense team. We talked about L. Linwood. We talked about his other attorney from Bainbridge, John Pierce, and there's some serious concerns that are happening there. And fortunately, there's been some movement on that. We don't know exactly what that is quite yet, but we're going to dive into it. So let's take a look at what's going on in his case. Currently, Kyle Rittenhouse is still in Illinois. So this is the record from Illinois. This is his court record, and you can see here that his next court proceeding is going to be on September 25th, and it's going to be the status of his extradition hearing. So this is in Illinois. This is all public records, so anybody can go look this stuff up. It's not special access. I'm not licensed to practice in this state, but all of this stuff is available on the internet, so please feel free to go check it out if you want. And so this is what's been going on. The public defender was discharged because he had a private attorney who came on board out of Illinois, it sounds like, and some motions were filed back in August, and then they reset the status of the extradition hearing for September 25th, which will be in about 9 days, it sounds like. So that will be very interesting to see what happens there. But something else happened on the other side. So remember, this all took place. Kyle Rittenhouse was involved in the Kenosha, there were protests that were happening there. Kyle Rittenhouse, 17-year-old young man, came over from Illinois. He was there, and he had a firearm, and he was there as part of a kind of an entourage of people who were there to protect property and sort of counter protest to BLM. And while he was there, he got chased down by an individual and fired some rounds at him. He was shot and killed. Kyle was running down the street. Some other people from sort of around the mob came and were lunging at him and attacking him. He fired back there as well. And another person died and another person was shot. After that entire scene happened, Kyle walked towards the police, put his hands up, said, "Hey, I'm right here," and the cops sort of just drove right by him, very likely going to attend to the people who were also involved in the altercation and make sure that everything calmed down a little bit. But when the entire situation wrapped up, Kyle actually went back to Illinois, and he was arrested in Illinois. So this status of the extradition hearing is going to be about that. Is Illinois going to send him back over to Wisconsin and allow the Wisconsin courts, which is where all of this happened, to deal with him in the way that Wisconsin wants to deal with him? And so, states can be finicky with this stuff. Extradition rules, extradition laws, it's a whole beast in and of itself, because Illinois may want to protect its citizen against anything that Wisconsin wants to do. It's just like, two countries. Like if the United States had me, a nice young citizen here who's very productive and has a life and everything, and China came over and said, "Well, we don't like that guy. We want you to just extradite him to our country because we want to prosecute him for whatever reason." obviously that would be a big problem, right? You would hope that the United States government would not want to allow that to happen. They say, nope, he's our citizen. We're going to protect him. Good luck. Do what you got to do in China, but take care over there. Same type of thing here on a much lower scale, because we have interstate compacts and we've got, extradition rules and all sorts of stuff. But it's the same type of concept. There's legal due process that needs to go forward. We need to go through the motions and have these court proceedings before Illinois can just say, oh yeah, Wisconsin, you want him? Here he is. Come and get him. They're not going to do that. So we've got a status of an extradition hearing coming up on the 25th. But today we also saw something happen on the Wisconsin side. So we're waiting until the 25th in Illinois. But in Wisconsin, there's been something interesting happened today. And if you look closely at the court record here, this is directly from the Wisconsin courts. And you can see here, we have a new attorney has entered the game. So last week I talked about L. Lynn Wood and we talked about John Pierce, but we have a new individual here who is Mark Richards. Mark Richard entered his appearance today, so 9/16. And this is all we've got. We've got a notice of a retainer, and the additional text is Attorney M. Richards. And so, I certainly shared some of my concerns about the prior attorneys, the preceding counsel that were on the Rittenhouse case. But let's take a look at this new individual, Mark D. Richards. Now, before we dive into his bio, it's important to note that we really don't know what's going on with Kyle Rittenhouse and his attorney situation. We can only see this minute entry that was entered onto Wisconsin court website, but Mark Richards could be sort of an of counsel, or he could be somebody who's appearing, who's part of the Linwood team or of the John Pierce team, but because he's actually licensed in Wisconsin, he's going to be the attorney who's boots on the ground doing those things. Remember, we talked about the two other attorneys, and they're not even from Wisconsin. I don't think they were really even criminal lawyers, and I highly doubt that they know anything about Wisconsin procedure or the Wisconsin prosecutors or the Wisconsin judges or even the Wisconsin laws. I mean, you can read the laws and learn those things, but there's something special about practicing in a certain area and getting a feel for how people do things and how the judges sentence people and what kind of oral arguments they're going to listen to and what types of motions they'll entertain. And this is why it's kind of called practicing law, right? If anybody could just read a statute and apply facts to that statute, you could have computers do the law. But what we're talking about here are personal relationships and what are the demographics of this particular jurisdiction and how do the prosecutors act and so on and so forth. So, it's very important that they have a local component. And so I don't know at this point in time whether Mark Richards is his new attorney, if he's going to be replacing the other two attorneys, if he's going to be handling the Wisconsin case entirely, or if he's just sort of an extension of the other attorneys who's brought in to just step in and help provide some guidance and some counsel as this goes forward. But I think it's good news either way, right? I think it's very important that we have somebody who is competent, who is on Kyle Rittenhouse's team. Not to say that the other two are not incompetent, but they are incompetent, but they've got some issues, clearly. We spent almost an hour dissecting through all of them, and my position was, when you have other attorneys, you've got so many outstanding issues that are sort of overshadowing the client's case. Those attorneys, they got to deal with those issues and get rid of them so they can focus on the case, or the client needs to get a new attorney. You got to look out for the best interest of the client, of the defendant, the person who's sitting in custody. Kyle Rittenhouse is still sitting in custody. And a lot of what I have seen from the other two attorneys are more talking about, I don't even know what they're talking about, quite frankly, but it's not on point. And so when I saw this today, I was pleasantly surprised. So let's take a look at Mark Richards. Mark D. Richards, and his bio comes from his website, which you can check out. If you just Google his name, Mark D. Richards, you will find it. And it says here, for over 30 years now, Mark D. Richards is focused on providing quality representation as a criminal defense attorney. So 30 years, and he says he's a criminal defense attorney on his website, which is amazing. That's good news. We looked at the other two websites, and I didn't see much criminal law, if any at all. So what does he focus on? Homicide. Focuses his practices on homicide. It's the first one. Drug charges, sexual assault, burglary, theft. So sort of the classic criminal charges. He says criminal defense is a specialized area, requires someone with experience, knowledge, know-how, and so on. Person's liberty is at stake. The stakes can be no greater. I really believe that. I don't think that the stakes could be greater in anything, in any other area of law than they are in criminal law. This is why the cornerstone of all clients' representation is a thorough investigation, both factually and legally, so that no potential defenses are left unexplored. I always like when I see a defense attorney talk about defenses, because a lot of the time they don't. It's kind of funny. If you look at different marketing websites, they don't really talk about, about defenses. They talk about the law a lot. You'll get a lot of the law. Tons and tons of law. What is the law? They'll tell you on their website, well, if you get convicted of a DUI, here are the penalties. You can go to jail for this, and you can pay this fine, and you can get probation for this amount of time, and you have to get an interlock device and all those things, and they'll give you all of the law. Next time you're on an attorney's website, look for that. But they don't tell you about the defenses. They don't tell you the how and the ways that the defenses work, which I've made a big point to try to provide education about that, specifically here on this YouTube channel. Before this show sort of was a thing, that's all I did was just talk about defenses and the law, and a lot of law, no question about it, but a lot of defenses. So, and my point is, this guy is talking about defenses, which is great. He's also saying, leave no stone unturned, which is very standard criminal defense language. No case is too big or small, which means he'll probably take, some of the smaller DUIs and things. And he's also tried over 100 jury trials, ranging from simple 2-day operating while intoxicated, so that would be like a DUI, to month-long homicide or drug conspiracy trials. If you were someone so on and so forth. So that's good news. This guy has a lot of experience, and he's a sharp-looking fellow right there. He looks like he probably has a lot of confidence and presents well and looks good in the courtroom, and people will be receptive to his message. And, the judges are going to know this guy. If he's been practicing criminal defense law for a very long period of time out of this jurisdiction, they're going to know him. And we're going to learn more about him, I'm sure. We're going to learn more a little bit about his reputation and how he handles these cases. And he may start, putting out some public statements, and we'll see if he does. But this is going to be a very interesting case to continue to follow, and we will certainly do that. So that's the update on Kyle Rittenhouse. Let's see if I have anything else. I do not on that one. So his next court date, the next one that we're going to be looking for, is going to be on September 25th. And that's going to be the time where they tell us, or we hopefully will know a little bit more about what they're doing. Are they going to move him from Illinois to Wisconsin, or are they going to keep him in Illinois? What's going to happen? So there's going to be a lot more to dive through when we get there. So if you're not already a subscriber here, hit the subscribe button, because we've got a lot more coming on that. All right. And those are the 5 updates that we have for today. So let's take a look at the comments. Let me hop on over, see if we've got any questions. I got a lot of people on here today, which is super exciting. Thanks so much for being here. All right, let's run through some of the comments and see what we've got. So, R&R Law Group, this comes from Rook. Is there a legal case to make that the McCloskeys threatened the protesters with a gun? In that case, could you reasonably charge the McCloskeys with the assault? So this is a great question. Yeah, this is a great question. And it really is going to depend on the law in their particular locality. So let's use the Kyle Rittenhouse case as an example. In Kyle Rittenhouse's case, there's no question that he shot and killed somebody. And there's also no question that he intended to shoot and kill them, right? Or to shoot and probably kill them. He really intended to stop them from chasing him or from killing himself, but he did intend to fire the trigger. He intended to do it. And so he's being charged with intentional homicide. And so many people think, well, but he was defending himself. That's true, but he still did the intentional homicide. So he still shot and killed 2 people. And so they charged him with that crime, but as we read through the probable cause statement, we also saw that it was written in a way that almost every single factual scenario, almost every single paragraph had a self-defense component to it. So we can know that he did intentionally shoot and kill somebody, but the self-defense component is so strong that it invalidates the underlying crime. In my reading of the law and my interpretation of the facts. Now, the prosecutor's office obviously thinks differently, but it's the same. It's a little bit more clearer in Kyle Rittenhouse's case, but it's the same type of analysis that you would apply to the McCloskeys. The McCloskeys, yeah, they technically were brandishing firearms. They technically were pointing weapons at other people. We saw Patricia, we saw Mark. Presumably, there are people on the other end of that line of sight. So presumably the guns are being pointed at other people. And so, yeah, the prosecutor could come back and say, yeah, technically, yes. Were they brandishing firearms? Yes. Were they pointing a firearm at somebody else? Yes. And a lot of that activity is criminalized under the law. So to your question, Rook, could they charge them with assault? The answer would be yes. But the defense would be they were on their private property. These people broke onto their private property. They were physically coming onto their land, which we now know is true because 9 of them got cited, and they were in reasonable fear of imminent injury or death or property damage or whatever it is. Whatever the defense specifics in this jurisdiction are, that would alleviate them of any criminal liability from it. So at that point in time, it becomes up to the prosecutor. Does the prosecutor want to charge them or not? And obviously Kim Gardner does, and I think she's making a big deal out of it. She wants to charge them, and she's going to basically say that the self-defense, that any of the excuse that would alleviate them from having that criminal liability, she's going to say it doesn't exist. So this is where you have to ask yourself as a prosecutor, why are you filing these charges? I ask myself this all the time. Why are these charges being filed? Why is this prosecutor doing this? And it's one of those things that some of them, you can't explain it. I've met many prosecutors who are just true believers. They just think that every single person who comes across their desk is a terrible person and they all need to be punished. I don't think that way about people, but there's other prosecutors who are very reasonable, but we don't know. And some prosecutors, like in my opinion, Kim Gardner, all they want to do is just amplify their public profile, generate more donations, use this as a media tool, and really, weaponize the justice system. That's really what this comes down to. A lot of these prosecutors are weaponizing the justice system. They are trying to use the justice system to serve their political ends. And this case, the McCloskeys and the Rittenhouse case, think about the political issues here that are surrounding these things. If you took the politics out of both of these cases, there weren't national news, there wasn't anything interesting about it, and you just had them sitting in court, and it was me and a prosecutor, I would like to think that the prosecutor, who's also a human being on the other end, would say, yeah, I get it. He was running away. He was getting chased down by 3 people. Of course he fired back, right? You would think that you could have that conversation, but unfortunately, you just can't. You just can't. So some other questions. BBE 556MM says, thank God for defense lawyers. Thank you, my friend. Justice. Let's see some other questions. Ruck. Rook says his name is pronounced Ruck. All right. Couple other, let's see if there are any other questions. Is it illegal for a 17-year-old to openly carry a long gun in Wisconsin in public? What does the law say? So I actually haven't looked into that in a lot of detail, if I'm being perfectly honest with you. I've seen some conflicting reports that it's illegal, but then there's U.S. code. So here's what we're talking about here. I think you've got some conflicting rules on this. And quite frankly, it's the least serious crime, in my opinion, of everything that's on that on his charges for Rittenhouse. It was a low-level misdemeanor, and I don't think it's really where our attention should be focused. So I haven't spent a lot of time on it, but there are conflicts of interest between state law and federal law. So anytime you've got, there's federal law, the federal government has its own set of criminal laws that are executed by the Department of Justice. The FBI is like the police department, and all of this is happening on a federal level. My understanding is that the U.S. code provides some sort of leniency or some sort of availability of permission for Kyle Rittenhouse to travel into Wisconsin with a long-armed rifle and be in compliance with federal law. There's other commentators who were saying that's true, but Wisconsin criminalizes it. You're not allowed to do it under Wisconsin state law. So I don't really know what that conflict is. I think that it's probably going to be pretty inconsequential. Really, it's a misdemeanor. The others are felonies. If he got convicted, let's say, for example, he got off on all of the other murder charges, which in my opinion he should, but he's convicted of the misdemeanor charge, he's going to get credit for time served. There really is basically no penalty for that. So I just haven't taken a super deep dive into it. All right, let's see. And I'm sure there's probably some commentators here who know better than I do, quite frankly, because I just have not. I've not taken a look at that particular statute. All right, so let's go back, see if there's any other questions. Got some good comments here. A lot of activity. I love it. Lala says he didn't even carry the gun into Wisconsin. Rittenhouse's lawyer claims the gun was not brought into the state. It was given to him by a local, so it never crossed state lines. He didn't travel to Wisconsin with the gun. The gun was given to him by people he was helping. Gun never crossed state lines. Too many conflicting laws from state to state. Constitution must be valid in all states. This man was highly trained. I got that impression too. I've seen some people saying he's 17 and he didn't know what he was doing with the gun, but we went through that. Remember when we went through that frame by frame and we analyzed every single angle of the Kyle Rittenhouse shooting, and there's a point at the very end where I think a lot of people kind of gloss over it because they're looking at the people who were shot. And Kyle Rittenhouse is on his knee and he is pointing a gun directly at another person who was rushing towards him, and he doesn't shoot that guy. You see that guy just come to a dead stop, put his hands up, and Kyle doesn't pull the trigger. And from what I saw, for a 17-year-old young man like that, and I had, I've got firearms myself. I thought that was very, very disciplined that he did not pull the trigger on that, because he was getting bombarded from all different angles, and that other guy was right on top of him, and he points the gun at him, and the guy puts his hands up and he stops, and Kyle doesn't pull the trigger. He lowers his weapon, he turns around and walks away. And I thought that's pretty stellar. What my interpretation was, he was using the absolute minimal amount of force necessary to protect himself, to not, to basically dissuade this mob from attacking him. And he did that. Once he accomplished that goal and once they were backing off, the entire interaction ended, and he made his way out of there and out of the police. All right. Let's not be so sensitive. He was hit over the head with a skateboard. Yeah, he was. And then the other guy was chasing after him with a gun. And RP Jax says that he handled the weapon well from my point of view as an 18-year veteran with combat tours. That's good confirmation. Somebody asked, what firearms do you have? I also have, according to many people, I also have an assault rifle. I certainly do. I've got several handguns, and I've got a 12 gauge shotgun too. I've got. I don't want to tell you everything, but I've got enough that I enjoy it. I think it's a good hobby. I think it's a good sport. I think it's very important to how we live our lives. So I'll tell you this. I got my mom her first gun on her birthday. First gun. She has never asked for it. My mom, my entire life, has been somebody who said, I don't really like guns. What do you need a gun for? They're super dangerous. And for the first time in my whole life, she wanted a gun. It was this year. And I don't think she's alone in that. I know a lot of people who really want to start protecting themselves because they're seeing what happens when they don't have that option. Yeah, don't tell us everything you have just in case it gets lost in a boating accident. What a good song. Mom's packing, baby. That's right. She's locked and loaded. So I'm pretty excited that she is coming on board. All right. Well, listen, I love these comments. It is a lot of fun that you're here. I really appreciate you being here. It's very exciting to me that there's people interested in this stuff, in this topic, because I think it's important. Justice is so foundational to everything that we do. If you're living in a system where people are getting taken advantage of, and the people in the positions of power are not being held accountable to the same standards that you or I are held to, it's a big problem. And so we want to make sure that we are doing our part to hold everybody accountable and really increase the transparency of a lot of the stuff that we see. So I want to thank everybody for being here today. If you are not already subscribed, hit that subscribe button, and do me a favor, share this show. If you like how we do this analysis, if you like some of the cases that we cover, and you want to continue, to have this conversation, send it to some people, tell them to come on over. We'll be back here next week on Wednesday, and I really look forward to seeing you then. Thanks again so much for being here, and have a wonderful